So we have the last panel of the day, and it's going to be about how the Charter will change. And we have four fabulous speakers. I'm going to spend very little time introducing them because their CV and what they're talking about is all in the program. So just a couple of words. We're going to start with Alison Latimer, who's a lawyer at the Vancouver law firm of Ferris, Vaughan, Wills and Murphy, which means nothing to anybody, except that you should also know she's an associate of Joe Arvey, and she and Joe Arvey have just moved to that firm, and she's been with Joe for a few years and has argued cases like Conway with him in the Supreme Court of Canada. We then have Audrey Macklem, who's a professor at the University of Toronto Law School, but her claim to fame is that 25 years ago, she was my articling student. And so everything else since then has, I think, savored of anticlimax. And then we have Deborah Parks, the Associate Dean at the University of Manitoba Faculty of Law. And finally, we will have Professor Alan Young of Osgoode Hall Law School, who I have had the privilege of litigating against on a couple of occasions. And in fact, we had a case this year, although Professor Young tells me he will not be talking about that case. Instead, he's going to be talking about the Bedford case and the implications of Bedford. And there's no question in my mind that Bedford is the most important charter case to be decided this year, maybe in the last few years, and is going to be a real game changer for the future of constitutional litigation. So with that, I will call on Alison Latimer.
Thanks. I'm so pleased to be here and to have this opportunity to talk with you this afternoon about a more aspirational topic. So instead of looking back, I'm looking forward to where the Charter's going. And one site I see for possible change under the Charter is the recognition of positive socioeconomic rights for children under Section 7. So I thought what I'd do just briefly in my 15 minutes is go over some of the relevant Section 7 jurisprudence, some justifications for treating children differently than adults under Section 7, and finally just some kind of practical observations about some of the challenges of putting that kind of case together. So first, I think it's fair to say that courts have typically interpreted Section 7 as protecting negative rather than positive rights. But the Supreme Court of Canada has always left open the possibility that Section 7 may one day protect positive rights. And that came up first in Irwin Toy when the court refused to exclude the possibility that Section 7 protected Social Security, equal pay for equal work, adequate food, and on and on. Justice Arbour was the first Supreme Court of Canada justice to actually endorse an interpretation of Section 7 which encompassed positive socioeconomic rights. And that was in her dissenting judgment in Gosselin way back in 2002. And Gosselin, you'll recall, was a charter challenge to a differential welfare scheme that left those recipients under 30 significantly below the poverty level. Justice Arbour's interpretation of Section 7 was grounded in the structure of the Charter, which includes many other provisions that have positive rights, obligations, including the language rights, the specific language of Section 7, a purposive analysis of Section 7, which gave some meaning to the right to life under Section 7, Section 7's overall position in the overall context of the Charter, and finally the existing jurisprudence. And while the majority of the court didn't want to go there with Justice Arbour, they did agree that one day Section 7 may be interpreted to include positive obligations. And the Supreme Court of Canada hasn't revisited that issue about positive rights under Section 7 since Gosselin, but some of the lower courts have. And so, for example, in Ontario, this year, the Ontario Superior Court heard an application for recognition of a positive right under Section 7 to affordable, adequate, and accessible housing for all Canadians in a case called Tanujaja. The court dismissed the application as disclosing no reasonable cause of action and raising issues that were not justiciable, a very disappointing outcome for the claimants in that case. And the court concluded that in Ontario, at least, it was settled law that Section 7 could not include positive rights. A notice of appeal was filed in that case in October, but it hasn't been heard yet, as far as I'm aware. In British Columbia, the jurisprudence is a bit less hostile. There was a case called Pratton, which involved a claim by gamete donor offspring, and which was based in part in positive rights under Section 7. Both the BC Superior Court and the Court of Appeal dismissed the Section 7 claim, but both levels of court accepted that one day those rights might be available, and they applied the same analysis that Justice Arbour did in Gosselin. More recently in British Columbia, this year, the Superior Court considered a charter challenge to a government decision to cancel the mother-baby program in a case called Inglis. This was a program allowing provincially incarcerated mothers and their babies to reside together at a correctional center. In that case, it was argued that what was claimed was a positive right, and the court rejected that. The court said that what was at issue was a deprivation, and so it was a negative right. And they went on to consider the principles of fundamental justice, of arbitrariness, overbreadth, gross disproportionality, and they upheld the law under Section 1. The trial judge declared that the decision to cancel the program was contrary to Section 7, and she directed the government to administer the legislation in a manner consistent with her reasons. In my view, the outcomes and reasoning in Inglis on the one hand and Tanu Jaja on the other are hard, if not impossible, to reconcile. In both cases, rights-enhancing programs were implemented and then restricted or canceled. In both cases, reductions of these programs had significant negative impacts on the people who relied on them, including loss of custody of children. In the Ontario case, the Ontario Superior Court said this was a positive rights claim and it was absolutely barred by the prior jurisprudence. In British Columbia, the court applied a negative rights analysis and reached the exact opposite conclusion. So what can you take from all this developing jurisprudence? In my view, it's at least interesting that both of the recent cases in British Columbia had children in their factual matrices and raised issues of treatment of children. So one observation that I would draw is that there appears to be some judicial appetite and ability to respond to socioeconomic wrongs, especially when those wrongs directly impact on children. But we also see a hesitance to recognize a positive right in fashioning this response to this socioeconomic wrong. And it seems to me that this reluctance may stem, in part at least, from what I might call sort of a liberal anxiety about the importance of state non-interference with autonomy, and also a worry about sort of institutional competency and capacity issues. So with those two concerns in mind, what I'd like to do is suggest a way forward for social justice advocates. And that way forward, in my view, is to consider the ways in which it's possible to distinguish children with respect to both of these concerns and urge the courts to recognize positive rights for children. The primary way to distinguish children is with reference to two things. First, their particularly vulnerable nature, and second, their capacity for growth. And I'm going to elaborate on that. Children's basic vulnerable nature is probably so obvious that I don't need to say very much about it. Professor Nussbaum has done some interesting work describing human infants and their basic capacities. She described human infants as being in a condition of needy helplessness more or less unparalleled in any other animal species. And I think that's probably fair enough. And this dependence makes children really ill-suited to the traditional liberal approach to Section 7, which implies a rational, autonomous individual who can exercise free choice and who requires only freedom from governmental interference in order to flourish. But it's not only this dependence, but importantly, a child's capacity to grow and to develop, and to become eventually a fully autonomous rights holder, which sets children apart and which drives the state and the courts, actually, historically, to treat children differently than adults. And in my paper, I've developed a little bit why this capacity for development is one principled reason to recognize a positive right for children in the interests of justice. And when I'm talking about justice in this context, I'm not talking about compensating for sort of arbitrary, natural, social differences in the distribution of goods. So, for example, you see a hungry child and you say, we should give this child food, or a poor child, give them money. I'm talking about a theory of justice I'm drawing on a theory of justice that was developed by Rainer Forst, which sees justice as requiring that all individuals have equal opportunities to participate and to wield influence in society's most important institutions. So it's a very public conception of justice. And my point is that, at least for children, a failure to treat a symptom of injustice, like hunger, will compromise child development and ultimately compromise autonomy and self-reliance and lead to a greater chance of adult exclusion from participation in these important institutions. And so I've taken that theory and I've looked to the Canadian legal landscape to see if it resonates with the law's treatment of children in general. And I see many sites where the state and the courts have recognized and taken special measures to protect children's particular vulnerability and also their capacity for growth. The state gives expression to this recognition when it enacts legislation which recognizes these dual attributes of children. This arises in the civil context with the recognition that the best interests of the child are always paramount in, for example, family law. And state recognition in responsibility that has to be taken for children in child welfare proceedings. It also arises in just a host of laws limiting children's ability to make autonomous choices about everything from driving to drinking to marriage, and the list goes on. In the criminal context, we see it as well, and it's even more stark. In the criminal context, we see offenses which are directed specifically at punishing offenders who target children as victims, but we also see a whole criminal system that treats child offenders differently in order to protect their rehabilitative potential. And so we also see this in international instruments about children. Specifically, I'm thinking of the Convention of the Child, which has been described as the most universally accepted human rights instrument in history. The courts, on the other hand, give expression to recognizing these same attributes in many contexts when children come before them. Particularly, they do so when they exercise their parents' patriae jurisdiction, which the courts have said extends as far as is necessary for the protection and education of those within its ambit. But we also see this recognition when courts interpret legislation that deals with children. And especially if they're interpreting statutes in the common law in conjunction with the Constitution. And this arises very clearly in the context of medical decision-making and minors. A common law, the mature minor doctrine reflects a tension between autonomy on the one hand and child protection on the other. The doctrine recognizes a child's evolving intelligence and understanding and maturity, and the degree to which maturity is scrutinized intensifies in accordance with the severity of the potential consequences of the treatment in question or its refusal. Faced with statutory provisions governing medical decision-making and constitutional challenges to these provisions, the court has given constitutional protection to these competing concerns when it says you have to interpret the statute to allow the child an opportunity to express their mature wishes, but on the other hand, that need to recognize that autonomous decision gives way the more serious the healthcare in question becomes. And when a child's very life is at stake, courts have always stepped in and required the treatment to be given. The courts have recognized that protection of a child's right to life and to health, when it becomes necessary to do so, is a basic tenet of our legal system, and legislation to that end, they have said, accords with the principles of fundamental justice. So to the extent that there's a tension between autonomy on the one hand and protection on the other, the court is likely going to take positive measures to guard the child's immediate physical well-being, in part in order to protect the child's capacity for development and his or her future adult autonomy. And this protection of development, or of future autonomy, ties back to this theory of justice I talked about earlier. And this is reflected in the court's jurisprudence when the court says it has to create and support conditions which are most conducive to the flourishing of the child. And it says it will choose the course which will best provide for the healthy growth, development, and education of the child, so that he or she will be equipped to face the problems of life as a mature adult. So it's a forward-looking protection. and that the court has been protecting this future development for children for centuries under its parents' patriarch jurisdiction is also an answer to the question of whether the court has the competency and the capacity to do so. And I guess by way of conclusion, I'll just briefly touch on some kind of practical observations about advancing a positive rights claim in the courts. I'm currently working with a couple of colleagues to develop a case that involves positive right to food for children. We're not yet at the stage of filing, and our hope is that childhood may be that special circumstance required by the court in Gosselin to recognize a positive right for many of the reasons I've explained just briefly today. But we're not blind to the challenges that would face this kind of legislation. For one thing, there are risks in focusing on children to the exclusion of adults in need of the same rights. Those risks include reinforcing incorrect and stereotypical views about the causes of adult poverty, and also negative assumptions about poor people's child-rearing abilities. It's obvious, because of these concerns, that great care is going to be needed to ensure that public advocacy and evidence assembled in this kind of case is responsive to these criticisms. But it's also fair to say, I think, that this need for sensitivity shouldn't deter charter challenges to insufficient state action in the face of deprivations of children's basic needs like food. What we can learn from cases like the Ontario housing case is that courts will likely retreat from more broadly based claims for positive rights because of concerns about the uncertain and possibly enormous impact that such recognition might entail. So there's a need to more narrowly focus any claims advanced and to find a creative remedy. But whatever the remedy, positive rights for children are urgently needed. Children in Canada are too often unable to secure their fundamental needs because of disparities of wealth, which may result in them living in poverty. And these conditions do compromise children's development and their potential for long-term autonomy and to function in this liberal state that we're in. And so in my view, these longer-term impacts are likely to perpetuate and exacerbate existing systems of inequality, and they cry out for a remedy in the interests of justice.
Thank you very much to the conveners of the conference for giving me the opportunity to be here today. I really appreciate it. I have come to learn that the subject matter of my presentation has largely been covered in the last presentation, so I'm kind of tempted to sit down. What I am going to be talking about is the convergence of the Charter and administrative law in the area of discretion, which I take to be one of the more difficult intersections to navigate in public law. So you can, if you've been here for the last session, I think you could see this maybe as dispatches from the uncanny valley of charter values. So here's the problem. You're at the intersection of the Charter and administrative law, standing there looking at an exercise of discretion. And the rules of the road keep changing. They point in one direction, follow the Charter, says Multani, and then another, no, go in the direction of administrative law, says Doré. And in any case, whatever you choose, you are guaranteed to arrive at the same destination, or so the promise goes. Now, in addition to cases like Multani and Doré that explicitly take on the problem of what mode of analysis to use in analyzing discretion where a charter issue is at stake, there are any number of Supreme Court of Canada decisions and others where those questions are buried in the case, but nevertheless the court has ducked the issue. And so to give you perhaps the most prominent example, think about Baker itself, right? The kind of the case that ate administrative law. The court there asserted that there was no need to consider charter arguments because the case could be resolved through principles of administrative law without having to deal with the charter, right? In this kind of sequential approach. First, admin law, then if you need to, you go to the charter. But this kind of sequential approach only makes sense if by principles of administrative law you mean procedural fairness, which is in fact how the case was decided on issues of bias. But if you think about substantive administrative law, then the relationship between the Charter and administrative law is less sequential and more overlapping, kind of like a Venn diagram. And it really depends whether you want to see in that intersection, it's really about the Charter or it's really about administrative law. Recall that the court's analysis of discretion in humanitarian and compassionate consideration with respect to the deportation of a mother with several Canadian children, the court insisted that discretion be exercised in accordance with the statute, the regulation, guidelines, common law, international law, and the principles, or dare I say it, the values of the Charter. But in that case, it was only by ignoring the argument that the best interests of the child, or perhaps family unity, resonated in Section 7 that the administrative law decision about the exercise of discretion could somehow fail to engage the Charter, right? Because if you took seriously that either the best interests of the children or family unity engaged with Section 7 right, then you would have to think about it in the exercise of humanitarian and compassionate discretion. Okay? Think about Suresh. In Suresh, you might recall, the Supreme Court of Canada kind of left off by creating a constitutionally permissible discretion to deport to torture in exceptional circumstances, right? Generally, you shouldn't do it unless there are exceptional circumstances. So that creates a discretion to deport in exceptional circumstances. But it never explained how that kind of discretion could be exercised according to the Charter. More recently, in DeVito, a case where the Asper Centre for Constitutional Rights intervened, and I acted on behalf of the Asper Centre, the Supreme Court of Canada upheld the public safety minister's statutory discretion to deny consent to prisoner transfer from the US to Canada. But the constitutionality of the specific exercise of discretion on the facts of the case was neither argued nor decided. So these are just examples of cases where buried in the case is the issue of the Charter and discretion, even if it never rises fully to the surface or gets explicitly addressed. So I'm going to proceed from the court's most recent pronouncement in Doré, which is that as between admin law and the Charter route, and specifically Section 1 Oak-style analysis, when confronting the exercise of discretion that engages a Charter right, one should review it using administrative law principles, most notably the principles of reasonableness, that is to say, on what's called a standard of review of deference. So you look at the exercise of discretion with a view to deferring to it unless it is unreasonable. And that includes with respect to issues that deal with the Charter. So I want to orient my comments about this around two questions. And one is, what's at stake in this choice? What's at stake in the choice of going the admin law route versus the Charter route, and more specifically, going the deferential administrative law route versus the Charter? And secondly, what are some of the doctrinal challenges that arise in purporting to fold a Charter analysis into administrative law, a process that, to read Doré, you would think was seamless and unproblematic? I don't think so. So, on the first point, what's at stake? So, Doré does two things, right? It says, given a choice between administrative and Charter analysis, go with the administrative law analysis. And once you get to that administrative law analysis of discretion, what standard of review do you use? You use the standard of review of reasonableness as opposed to correctness. So, Doré chooses reasonableness, but insists that this will not dilute the level of protection accorded to fundamental Charter rights. So somehow you can apply a deferential standard of review, but still protect fundamental rights. Can you do this? Well, how do you defer to a decision that affects a Charter right/value without risking the possibility that in deferring you will uphold a decision that actually on your analysis violates the Charter, where if you were to approach the issue afresh and decide it, you would come to a different conclusion on the Charter issue. Okay? Well, in Doré, the court tries to massage this by saying, look, deference to reasonableness in the context of the Charter is not so different than the margin of appreciation that is applied in proportionality analysis under the Charter. I want to suggest to you that this comparison, reasonableness, kind of like margin of appreciation, is inapt for a number of reasons. And here I'll just identify one. Okay? The margin of appreciation has a particular meaning in European Charter jurisprudence, European Convention of Human Rights. I think it's being used in Doré to get at the idea that when you get to a certain stage of an Oak-style analysis, particularly the least restrictive alternative piece of the analysis, there's a little wiggle room for saying, you know, you don't have to choose the absolutely least restrictive alternative. We have to have a little bit of room here to defer, if you will, to legislative choice about which alternative here is not maximally restrictive of charter rights. So there's a little bit of wiggle room around what is the least restrictive or less restrictive alternative, and we're going to call that a margin of appreciation. Okay. But here's my point. When people talk about deference to discretionary decisions, they're not talking about applying a margin of appreciation or something like that to one little piece of the analysis. They're talking about applying it to the decision as a whole. So even if you thought that there was some margin of appreciation deference built into a proportionality test, as we understand it, it doesn't come close to the kind of comprehensive deferential posture that we think about in administrative law. So if we've got a problem here, that discretionary decisions that engage the charter are supposed to guarantee no lesser a protective outcome than you would get if you just applied an ordinary charter analysis, well, then you're not being deferential, right? If it's going to come to the same conclusion as you get to on the charter, on a regular charter analysis, that's not deference. And if it does lead to different results, because you're applying deference, then what you're saying is decisions that violate the charter that are wrapped in discretion are more likely to withstand constitutional scrutiny than decisions that violate the charter that are based in a statute or a rule. Well, this has significant implications for governance. Think now like a legislator. You want the maximum flexibility to do what you want to do. You want the least interference possible from the courts. This may sound like a government that is not completely confident in the rule of law, but work with me here. Imagine a government that wants to minimize any judicial intervention. How would you go about governing then? The way you would go about governing, I would suggest, is governing through discretion. You would make as much of your laws as wide open and discretionary, open-ended, vague as you possibly could, rather than stipulating statutory rules, regulations, and laws. Why would you do that? Because the courts are going to defer to how you exercise discretion, even where it implicates the charter, in ways that they apparently won't if you just subject it to an ordinary charter analysis. Okay? I would suggest to you that there's a lot at stake then in how we understand our interpretation of a proportionality analysis as run through administrative law. Okay? Let me talk now for a couple of minutes about the doctrinal dimensions of this, my second point. Can you reconcile a proportionality analysis with administrative law reasonableness review? Again, this is presented as a kind of unproblematic kind of alchemy that can be accomplished according to Doré. But let me point out a few things that I notice about reasonableness review and generally administrative law review under a standard review analysis. One is that we highlight expertise, right? You defer because the decision maker has expertise. Well, here, of course, we're talking about deferring to somebody who may have zero expertise in the charter, but that's not even the point. The point is, do they have expertise in a proportionality analysis? Are they going to know how to conduct a proportionality analysis? From my recent reading of a case from the Alberta Court of Appeal, for example, it's clear that some frontline decision maker, it's not only that they can't, it's not only are they thinking about freedom of expression versus, in that case, managing a campus security environment, it's can they possibly think of this in the language we associate with rational connection, least restrictive alternative, and so on? I think it's a bit of a challenge. The second and more significant concern here, I think, relates to independence. In administrative law, it is generally, if not always the case, that the higher up the food chain, the administrative decision maker, the more the courts are likely to defer. Ministers attract a higher level of deference precisely because of their proximity to the legislative branch. Whether the courts say this or not, I think if you track cases, you will find that ministers tend to attract a lot of deference in their decisions. If a minister is making the decision as opposed to a lowly bureaucrat, it must be because the decision calls upon the particular skills, perceptions, knowledge that a political actor, a senior political actor has, and so the court should defer. And if you look through case law like Inuit to Pirasat and more recently the retired judge's case of Ontario, I think you'll see that. Here's the problem with that, though. If it makes sense to defer to people the closer they are, the higher up the chain they are in administrative law, because of their stature and their legitimacy, it's precisely the opposite in charter litigation, right? It's precisely somebody's proximity to being a political actor that would make you want to be vigilant about how they exercise their authority in something that is going to affect a charter right. Why? Well, it's precisely because decisions by elected officials, our legislators, are subject to scrutiny precisely because they might be more inclined to trade off individual rights in the name of majoritarian political gain. So, how do you reconcile the deferential posture of administrative law that is predicated on a respect for of administrative actors, the closer they are, the higher up the food chain, with a concern that charter litigation has about protecting people from majoritarian tyranny and so on? And finally, the last point I'll make about doctrinal challenges is this. It relates to the idea of weighing. If any of you have been reading administrative law cases, as I have, as some of you have, you will know that the courts repeat a lot that when it comes to deferential review on a standard of reasonableness, the one thing you should never ever do is reweigh. You should never reweigh the facts, you shouldn't reweigh the evidence. That's not the job of courts on judicial review. They are not supposed to be reweighing, right? That is what you do not do when you're being deferential. Well, proportionality under the Charter is all about weighing. It starts from the proposition that something you call a right has normative primacy and priority over other interests. Charter rights way more than other interests. And it's their violation that the other side has to justify. It's not that I have to justify having my right respected, you have to justify violating it. So on both of those scores, proportionality is all about reweighing. So if you're going to do an administrative law analysis on the basis of reasonableness and you're not supposed to reweigh, how then are you supposed to be engaging proportionality? The fear, I think, that one might have about this is the fear that I understand was talked about in the last section about the work that calling something a value has as opposed to a right. A right has normative priority and primacy, but does a value? Is a value just something that you throw into the hopper with all the other factors that you're weighing, and you may trade it off in favor of some other value or right? It doesn't own any greater weight or priority or primacy than anything else. And if that's the work that calling something a value does, then charter right versus charter value is not a label, it's a conclusion. And it's a conclusion, I think, that bears consequences that are worth thinking about for the protection of charter rights in an era where increasingly risks and threats to rights come from the exercise of discretion. Thank you very much.
It's not often that you get to use a really good word like penultimate. And I stand before you today as the penultimate presentation that is keeping you from your weekend, and the only person that is, kind of in a more difficult position on some level is Alan, who is the ultimate barrier between you and your weekend. But yeah, but I do thank you for sticking around for this panel. I've found it to be terrifically interesting so far, as has been the whole day, and I want to thank Ben and Sonia and Jamie and everyone else who's been involved in this day. It's just been terrific. My paper takes up the question of change in the Charter in relation to penal law, policy, and practice. And in attempts to answer the question of whether the Charter can act as a meaningful check on an intensifying punishment agenda in Canada. And I use the term punishment agenda to describe not only an increasing prison population, but more fundamentally a policy agenda that's based on an ideology that more punishment, particularly incarceration, will make us safer. And that's an ideology that I suggest is not without problems and is often contradicted by significant evidence. I'm interested in what, if anything, the Charter and judges interpreting it have to say about this segregation cell, about about this. You can't see very well with the lights on up here, but this is Ashley Smith, a woman who died in a prison cell here in Ontario. About this, which is a story that was in the news last week, the massive overcrowding of provincial jail or territorial jail in Nunavut. About this, which is also about conditions in remand centers across the country. I suggest that focusing our attention on imprisonment matters, not only because of the charter issues that are raised by the actual practices of imprisonment and realities of what you see in prison, but also about sentencing and thinking about charter challenges in the relation to sentencing. Because we talk about imprisonment when we talk about sentencing and the charter, but we talk about it in very abstract ways, I would suggest. My paper identifies some limitations on the ability of the charter, and more particularly charter litigation, to act as a meaningful check on the punishment agenda. But I ultimately suggest that charter litigation about imprisonment by prisoners is valuable as part of a critical response to that agenda and to redress some of the concrete harms caused by it. In the time I have today, I will skip over any significant consideration of the various laws and policies that further the punishment agenda, but we know about many of them: mandatory sentences, the rise of many more mandatory sentences, the near elimination of conditional sentences, which were to be served in the community on strict conditions. Also, though, many other changes around the removal of language of rights, principles of restraint in criminal law from both correctional law and other law that governs sentencing and imprisonment. And I'll spend most of my time, though, talking about a little bit about case law under the section of the Charter that speaks directly to punishment and its limits, and that's Section 12, the right to be free from cruel and unusual treatment or punishment. And I'm just dividing that law into two strands today. The dominant strand being that which is considered mandatory sentences as under Section 12 review, and a second strand which I want to focus on a little more, dealing with prison conditions and treatment as violations of Section 12. And I'll just conclude with some thoughts on the limitations and potential of charter litigation in the prison context. So first, with respect to the impact of Section 12 on sentencing, and particularly mandatory sentences, the Supreme Court has to date carved out, I would suggest, a relatively minimal role for Section 12. I'm not the only person to suggest that. Much has been said about the extent to which mandatory sentences are bad policy. Research shows that they tend not to deliver on their promise to deter crime, and that they do have other unintended effects, such as pushing discretion down to prosecutors rather than to sentencing judges. But as folks in this room know, whether they are good policy or not is not the question that you ask under the Charter. So just a couple of points about this body of law. From the leading decision of Smith in 1987, we have the standard of gross disproportionality, as well as the concept that a treatment or punishment is cruel and unusual when it outrages standards of decency. This is the language we're working with. We are first to consider whether a sentence or other measure is grossly disproportionate in relation to an individual accused. Even if that question is answered in the negative, we're to go on to consider whether the measure would be grossly disproportionate in relation to a reasonable hypothetical. And in Smith, I'm just skipping over, lots of things here, but the reasonable hypothetical was a youthful first offender who brought one joint across the border, and the mandatory sentence was 7 years for importation. That was found to be grossly disproportionate. And while Smith was the starting point, and many would suggest high watermark for Section 12 review of mandatory sentences, the Supreme Court's interpretation and application since then has been, I would suggest, decidedly deferential to Parliament. A number of mandatory sentences have, of course, been challenged since Smith, but the Supreme Court has found only one other sentence to violate Section 12, and that's the Steele and Mountain Institution case, where you had a predecessor to the dangerous offender law, in which someone was imprisoned for 37 years in that case, and that was found to be grossly disproportionate. Yesterday, the Supreme Court granted leave to appeal in the Nur decision and at least one of the companion cases from the Ontario Court of Appeal. At issue was the mandatory 3-year sentence for possession of a loaded firearm or a firearm with readily accessible ammunition. And the Court of Appeal declared that mandatory sentence invalid, but I would argue on quite narrow and limited grounds. Justice Doherty for the court said that this mandatory sentence, along with the other mandatory sentences for gun crimes, were a rational legislative response to the very real public safety concerns of gun crime. The problem was only that Section 95 cast too wide a net, and the 3-year sentence was grossly disproportionate in relation to a reasonable hypothetical, namely a licensed gun owner who has an unloaded firearm and ammunition in a nearby drawer. And the hypothetical is a little more complex than that, but that's basically it. And it was the disconnect between this essentially regulatory offense and the 3-year penitentiary term that you got when the Crown proceeds by indictment that would outrage standards of decency, according to the Court of Appeal there. And so it's this distinction between true crimes and regulatory offenses that, to me, seems to loom very large in that decision. And it seems to, and I'm very interested in other people have different reads on it, largely leaves untouched, and I would suggest, in fact, bolsters the underlying logic of mandatory sentences. And if the Supreme Court does take a similar approach, and that's not an obvious thing, lately they've been doing different things than we might sometimes predict. If it's something along those lines and in keeping with the deferential history, then it doesn't bode well, I don't think, for the challenges that are winding their way up to the court. And there are a number of those across the country, including a couple from Manitoba that are only at the trial level now and going to our Court of Appeal in Manitoba soon. And I don't have time to talk about those right now because I kind of want to talk about the other part of Section 12 jurisprudence around prison conditions. But so I'll go there, but I'm happy to, if people want to discuss that in questions, that would be interesting. And I'll just move on to talk about Section 12 as a limit on treatment and conditions while in prison. And I'll suggest that while it has always had also had a relatively minimal impact in that venue as well, I suggest that charter litigation by prisoners is valuable as part of a critical response to the punishment agenda for a variety of reasons. And I've written elsewhere about the history of prisoner litigation, and I have noted that the limited gains have largely been in the context of procedural rights, so rights to a hearing, rights to counsel in certain situations where residual liberty is at stake. Of course, prisoners very often don't have access to counsel, don't have access to legal aid. An exception to this, to the sort of procedural focus of most of the law is, of course, the Sauvé decision in 2002 on prisoner voting rights. And that decision to declare a prisoner voting ban invalid is based on very strong normative statements about prisoners as rights holders and not, as the Chief Justice says, quote, temporary outcasts from our system of rights, end quote. The caveat about that case is that it is very much about symbolic punishment, and the usual arguments that you see in prisoner litigation, to the extent that you look at it, is they are about safety and security of the institution, and those simply didn't play out in that case. A key point I want to make, though, is that a considered charter analysis of many, and this is where we see the charter potential for change point, is that a considered charter analysis of many of the practices of punishment and conditions of confinement in Canadian prisons and jails have simply not been undertaken by Canadian courts at any level, let alone at the Supreme Court of Canada or at appellate levels. There are, for example, significant Section 7 and Section 15 issues about a range of correctional practices, discrimination in security classification systems, cancellation of needle exchange programs around harm reduction, and there is some litigation underway around that, but many other issues that just simply have not been adjudicated. And I should say that a recent, very significant, considered trial-level decision, and it was mentioned by Alison, the Inglis case is a kind of a contrary example in which, that was a success for the prisoner claimant, and it was a successful Section 15 and Section 7 case. But with respect to Section 12, and I wanted to interrogate Section 12 more for this paper because it's one that we don't actually talk about that much outside of mandatory sentences. It has to date had relatively little application in relation to prison conditions. So there were some unsuccessful lower court challenges in the early days of the Charter to double bunking practices, for example. But those were not, I would argue, very fleshed out cases in many ways. And I just want to point to a few recent cases in which prisoners have successfully argued that they've been subjected to cruel and unusual treatment or punishment in relation to solitary confinement, which I would suggest is one of the a very significant human rights issue both in Canada and internationally right now, and other inhumane practices. So the 2010 decision of the British Columbia Supreme Court in a case called Bacon and Surrey Pretrial Center is an example of a careful judicial analysis of the actual conditions and impact of solitary confinement against a constitutional standard informed by international human rights norms and expert evidence, something you don't often see in prisoner litigation. Justice McEwen was not prepared to find that solitary confinement was per se cruel and unusual treatment or punishment. And in the paper, I talk about some of the growing body of evidence around the long-term psychological impact of solitary confinement, both that's being gathered internationally right now. But he wasn't prepared to go there, but he did say, though, while there is a growing sense internationally as well as in Canada that locking a person down for 23 hours a day is an inappropriate way to treat any human being, the courts remain tethered to the standard of gross disproportionality. But in holding that the conditions of administrative segregation imposed on a pretrial detainee in that case, so on remand, and someone, I should say, an accused with some means to launch that kind of challenge, they amounted to cruel and unusual treatment or punishment, and the judge refused to apply the excessively deferential standard that is often found in prison cases. The judge had strong words for the correctional authorities in British Columbia, so it's a provincial imprisonment case, which he said had, quote, seriously lost sight of their responsibility to the judicial branch, end quote. The idea that prisoners are entrusted to lawful custody by the courts. Similarly, in a decision released last month in the Northwest Territories, a sentencing judge in a case called Parmentier found that the conditions of solitary confinement and the denial of basic items such as clothing, running water, a mattress, and bedding that the accused had been subjected to while on remand amounted to cruel and unusual punishment. He received a reduction of his sentence to recognize this. And a point I want to make is that prisoner litigation, and particularly charter litigation, to challenge inhumane conditions and treatment imprisonment arguably has more potential to challenge the punishment agenda than litigation to challenge mandatory sentences. Not that I'm suggesting we should do one or the other, but we don't do much of the prisoner litigation for a variety of reasons. There are, of course, limitations on this kind of litigation. One is that there's just simply very limited access to the courts. Many legal aid, actually Ontario has some legal aid funding for prisoner cases, but many legal aid programs across the country simply don't fund it in any meaningful way. Judges are still often quite hands-off when it comes to safety and security. Another big question is around remedies. And in some of the cases that I canvass, you simply have a charter declaration of a rights violation, and that is simply not a meaningful or adequate remedy, I would argue. And I have been one of those people that's been arguing for some time now that judges should be looking to the what some call the Arbour remedy from Justice Arbour's 1996 Commission of Inquiry report into the events at the prison for women in Kingston, where she suggested that courts retain jurisdiction over the integrity of the sentence, and it should be open to lawyers to argue on behalf of prisoners, sentenced prisoners, that their sentence should be reduced after the fact to account for an illegal sentence actually being undertaken. And so this Arbour remedy is one that I suggest has some potential and has only been taken up in one case that I found. Okay, thank you.
I know it's Friday, sunny. I got one word in my head. You should too. Barbecue. I can taste it and smell it now. Anyways, thank you very much for inviting me to this. Occasionally I'm asked to do this conference, and I don't do a lot of conferences because I talk too much in life and I like to get away from talking. But this is one I'll always do because it's always well organized. And I thank the organizers, even though they've changed over the years, it's always been a very good conference, and the publications are very useful. So thank you for inviting me. I was asked to speak to you people about the future impact and implications of Bedford. What do I know? I mean, I did argue the case, but I mean, the future, I'm not Nostradamus, and I really don't have a sense of where this is all going to go. And then I started thinking, what would I say about the judgment? And I started thinking, okay, you know, it's brilliant, it's groundbreaking, it's landmark, and I felt awkward saying those things because of my involvement in the case. Plus, you know, I usually lose most of my cases, so I've been way more comfortable in the role of critic than cheerleader. So I tried to think, what could I tell you about that I think may be problematic in terms of Bedford? I think we know what the good parts are. And I came up with something that I found somewhat anomalous and possibly troubling, and it has to do with proof of a violation and legislative fact evidence. And it could be just a throwaway comment. I'm not really exactly sure why they said it other than for its rhetorical flourish, but this is what I wanted to talk about today. The conventional wisdom is that Bedford was successful, Insight was successful, Chiali was successful, Carter was successful in the first round because they're all evidence-based challenges. And evidence-based challenges on a wide array of legislative fact evidence are the most compelling challenges you could bring. And I think there's some truth to that because if we do look at what's happened in the last 10 years of Section 7 litigation, we've turned courts into commissions of inquiries. I mean, when I read the polygamy decision, I didn't even know there were that many polygamists who could testify in a court of law and provide affidavit evidence. And it's all following a very similar pattern that we're developing. One, you get a lot of what it's called anecdotal experiential evidence, people that are affected by the law. Then the icing on the cake is to try to bring in some empirical data like they did in Insight, which was actually commissioned for the case. And then finally, if you're lucky, you get government reports that may support your position or may not, and they can be domestic or international. And at the end of the day, when you put this all together, what do you got in Bedford? You had 88 volumes of material, over 60 witnesses, over 25,000 pages. And I thought that was pretty big. And then when I looked at the polygamy case and some of the other cases, even Inglis, which was just mentioned, the record is so voluminous, I really don't envy being a judge in the modern era of constitutional adjudication. I mean, we are overwhelming the judges. Now, what I found puzzling in Bedford, because I am a big fan of legislative fact evidence, that a court should have a contextualized decision, but you know, I'm reading through the decision and I come up to paragraph 122, and the court says this: gross disproportionality is not concerned with the number of people who experience grossly disproportionate effects. A grossly disproportionate effect on one person is sufficient to violate the norm. Now, I know that sounds right, but my first thought was, why the hell did I spend a year collecting all this evidence if all I had to do was put Terry Jean Bedford forward to say that I feel safer when I worked indoors in my dungeon? Or Amy Leibowitz, I don't want to lose my home by working indoors in a safer environment. Why do we go to the trouble in the federal Crown too with their 33 witnesses if all we had to show was a grossly disproportionate impact on one person? I felt a little silly, actually. And then I noticed when I read the decision, they don't mention any of the legislative fact evidence. Look at it. They go through Bedford, Scott, and Leibowitz, and you don't have any sense of the statistical data, the empirical studies, the differential studies. It's all just left to a concept of deference to the application court judge. And I think that's dangerous too. A single judge now is creating public policy that will bind higher courts and government. That's pretty dangerous. So what are they getting at here? Are they sick of the legislative fact, commission of inquiry cases? Why would they make this statement? And conceptually, you got to understand, this statement is made in the context of invalidating a law. Do you invalidate a law because one person who might be uniquely situated is adversely impacted? That can't be what the charter was designed to do. And I like to consider myself fairly progressive and liberal in this area, but I think that's going too far. As they said in the child porn case, the Sharp case, most laws are substantially constitutional and they may be problematic at the periphery. So this was not a personal remedy case. This was not a remedy for Bedford or for Scott. It was invalidation. So it's not a very nuanced approach, and it really creates a zero-sum game to constitutional adjudication where I just bring in one person who's adversely impacted and you lose the law. Is that what they mean? I don't know. But this is what I can tell you and what I wrote about in my paper about legislative fact evidence. In 1990, the Supreme Court was really clear, and I took this to heart in everything I've done in my career. In two cases called Danson and Mackay, they say, we need contextual third-party impact legislative fact evidence. Do not rely upon the unsupported hypotheses of enthusiastic counsel, which is like I thought I was building my career on. I didn't know anything about evidence gathering. I just knew that I could be enthusiastic and animated about my positions. So, at the same time they said that, we saw the most abysmal failure in constitutional adjudication, the 1990 reference in prostitution, which is why we have to wait 20 years to revisit it. It was a disastrous case, largely because there was no legislative fact evidence to show what the impact of the law would be on third parties. It was completely abstract. It was also, the charter was very underdeveloped. Even if there was facts, they may not have been able to respond. So it looked like the court was serious. Don't come to us telling us you want to strike out a law unless you show us how it's impacting society at large, not just the claimant before the court. So I then embarked myself professionally on a 20-year journey of trying to prepare legislative fact records, and I found the courts were really scared of the evidence. Very chilly receptions until actually Bedford. My first one was a challenge to obscenity law in a case called Emery, and I actually had Project P officers on a vagueness challenge who were going to testify in court that they didn't understand what the law meant. I thought that would be the greatest evidence of vagueness, and the judge excluded it. So I don't need to hear that. I can figure this out without legislative fact evidence. I read Danson and Mackay. It says, no, it's fine. We don't need that. And then years later, with James Strabopoulos, when he was my research assistant, we did a challenge to gambling, and we tried to prove there was no harm in gambling by putting in about 20 volumes of evidence about the $11 billion and 60 casinos the government has built. It's a two-page judgment. Nobody knows about it. It's one of my great successes. And the court mentions nothing about this evidence. It's like it didn't exist. And then finally, in the pot challenges, where we really developed a legislative fact record from BC and from Ontario, the court had a lot of trouble with it. I'm not going to get into details, but there are a lot of scientifically inaccurate statements made in that case because the court suddenly had to deal with dueling experts who both come from activist backgrounds who might characterize studies in different ways. And they did the best they could, but it really wasn't, I thought, their best effort. In my opinion, none of the evidence, legislative fact evidence, in the cases I was doing had any impact. But here's what happened with Bedford. While the pot cases were being litigated, something very troubling occurred. And you may remember sitting at your home, perhaps, in 2002, when they started digging up the bodies on the pig farm in Port Coquitlam with Picton. And it was a lot of bodies. And it was quite outrageous, as they were all missing street women that nobody seemed to care about. So this started to make me think that we should go back to 1990, the prostitution reference, because none of that was before the court. They had no sense of what it was like on the street. It was very academic. And then if you dig a little deeper after you read about Picton, this wasn't about Picton. This is an endemic, pervasive problem. You know, the same year they got Picton, they got the Green River Killer, 48 victims. The most prolific serial killer, at least documented in the United States. And when they picked him up, all he had to say was, I picked prostitutes as my victims because I knew they would not be reported missing right away, might never be reported missing. I picked prostitutes because I thought I could kill as many of them as I wanted to without getting caught. It's like, wow. The law has to have something to do with that because the law sends out messages about stigmatizing sex workers. Sure, the psychopath is responsible for the death, but there had to be something in the law. And then we started to notice in Stats Can reports that they were calling prostitution an occupation at risk. 3 occupations they put in the category: police officers, taxi drivers, and sex workers. And you can add up all the cops and taxi drivers who've been murdered and won't even come close to 10% of the street sex workers who've been killed in the last 20 years in Canada. So the question became, now there was some very powerful legislative fact evidence about third-party impact of the law. And how do you fit this into an existing charter claim? Because the Supreme Court of Canada in 1990 knew this was a bad law. Read it. They call it anomalous, they call it bizarre, but they couldn't figure out how to characterize that as a constitutional violation. So this is what actually happened, and just a stroke of luck, and people talk about the charter as an evolving living tree. I guess it is, but it's more like a mutating tree. You never really know where it's going to go. And so you know, when Clay, Kane, and Malmo Levine came down the pot cases, these looked like they were door-closing decisions. What happened was we argued there's a harm principle, a threshold of harm that Parliament must meet. The court said no, in effect giving Parliament carte blanche to criminalize whatever they want. I think it's a horrible precedent, and it looked like it was really closing the door on substantive review under Section 7. But the court ended up saying something we didn't even argue. They wanted to get rid of our arbitrariness claim. We argued arbitrariness. We said the law is arbitrary because it was hurting young people, and the purpose of the law was to protect vulnerable youth. And our evidence was criminal records, you can't travel to the States, limited economic opportunity. And the court just wanted to tell us that's a stupid argument. That's what criminal law is about. People have limited opportunities if they're stigmatized by a record. But they didn't just say that. They said, if you want to raise this about the negative adverse impact of law, it's got to meet the standard of gross disproportionality. We never argue that. Those words never came out of my mouth in 2003 in the Supreme Court of Canada. They're really just saying this is not something we want you to argue. Only come to us with an arbitrariness claim when it's so excessive and outrageous it shocks the conscience. Well, what the court didn't realize when they said it, because they probably thought there would be no example of it, is there were examples. And the Bedford case was one of them, the Insight was the other one. When you put the facts together, the new emerging legislative facts, with the evolving gross disproportionality doctrine, you created a perfect charter storm. And it was something the court could not resist. I've had occasion to say through the course of the litigation that I found the claim to be incontrovertible. And it's not having to do anything with advocacy, it has to do with when you have a perfect combination of a doctrine and facts that meet that doctrine, that are also a matter of common sense, because we know the streets would be dangerous, you're going to get a good decision. But in my opinion, the decision is predicated on the fact that the legislative fact evidence shows that the harm is pervasive, recurring, and doesn't relate to some uniquely situated privileged sex workers. It applies to a lot of people. And the court's right. You don't have to go around quantifying the amount of harm. 35% of sex workers are hurt by the body house law. Social science never gives you those sort of determinate, conclusive results. So it's a quest doomed to failure. But clearly, I don't think the court wants to be saying that you start to strike out laws because at their periphery for uniquely situated people, it may have an adverse impact. But the court has boxed itself into this position by their aversion, for reasons I don't know, to constitutional exemptions. If the law adversely impacts you as an applicant, you get a personal remedy. It should be a constitutional exemption, or maybe read down the law so it doesn't apply to you. Overbreadth, you can read down the law. That was on the table in this case. So it's unclear to me if what's happening is the, how are we doing, 5 minutes? Okay. It's not clear to me. Yeah, I got you. If the court is suggesting that the love affair with legislative fact evidence in Dance and McKay is over, or they're also suggesting that they will invalidate laws that affect one person to set up a dialogue with Parliament because it's the only way to really galvanize Parliament into action. But I actually do believe, and I'll end on this note, that the courts are getting wary of what we're doing as counsel. It is overwhelming. I felt very bad for the application hearing judge who had to wade through all this evidence, sure, with the assistance of law clerks and the benefit of having a year of time. But I mean, we have people that teach courses in social sciences in this area that will debate this for 20 years, and yet some one person has to make a decision. Plus, the courts have made some pretty bad mistakes with empirical data. I can give examples, but I'll just say one. Ascoff, if you're too young for Ascoff was a 6 to 8 month statute of limitations based on a reasonable delay, based on a misapprehension of statistics from Montreal courthouse. And even the court admitted it in 1992 in Moran, scratching their head, said, I think we got it wrong. Secondly, when you get into areas like sex work, assisted suicide, pot, all the stuff I work on, they're controversial issues, which means that the people who tend to study them tend to be activists and advocates that have predetermined views, okay? And motivation affects perception even for the best scientists. So the court's being flooded sometimes with dueling experts that are all really speaking out of their ideological preferences and twisting and turning data to suit their purposes. Thirdly, As you'll discover, if you do a constitutional challenge, you want to start tendering government reports and affidavit evidence, there's no real rules of process and practice. Almost every case that I've done, just arranged with counsel to say, look, let's just tender everything, and then the judge will figure out what he or she wants to rely upon, which has worked well for my particular strategy in most cases. But if you think about it, it's not a very disciplined way of coming up with an accurate application record. So counsel of prudence tells me that if you are going to make a constitutional challenge, you should rely upon the legislative fact evidence, regardless of the court saying, show that your claimant is adversely impacted. I think all the court was doing was underscoring the universality of rights and saying, look, we're going to protect your rights even if other people aren't affected, but that doesn't really answer the question of whether you invalidate because one person is adversely affected. Other than that, I think it's a great decision. Have a good weekend.
Audience, and then before we wrap up, I'm going to have Professors Berger and Lawrence and Cameron come up to say goodbye to everybody, so don't leave until 5 o'clock, but we do have time for questions. Now, the first question goes to Michael Morris, who of course was counsel for the Federal Department of Justice in the Bedford case, and he may have a different perspective than Professor Young.
Well, actually, the astonishing thing is I've never said this in 7 years litigating with Alan Young, but I agree with Alan Young.
I did this just for you, Michael.
Alan, I think you're onto something incredibly important. I never thought it would come out of your mouth, so I stand here awestruck. But I think there are some issues flowing from Bedford exactly along the lines of what Professor Young said about, especially in relation to the breakdown of the distinction between adjudicative facts and social and legislative facts, and the fact that there's tremendous, there's already challenges for judges having to determine these on the enormous record that Alan's talking about in the context of these polarized cases, where it's very difficult to come to objective findings of fact and where judges will differ. So, for example, you may have a Justice Himmel coming to certain conclusions in one province and another judge in another province with respect to the same case coming to different conclusions, and whoever gets to the Supreme Court of Canada first gets the findings that get deferred to, which is a point that Bob Charney made in another context. And I think there's something that the Supreme Court needs to think about in relation to that. But I just wanted to get some of the other panelists picking up on what their thoughts they are about this potential box that Professor Young talked about in relation to how they make findings of fact in relation to social and legislative findings of fact, given the deference that's now going to be given to those findings of fact and what the implication of that is going forward in relation to that issue, particularly in cases like this, and what the court can do to try to perhaps better equip itself in cases like this, which we know this is not going to be the last one.
Do any of the panelists want to?
I'll say something about that. I'm counsel for the plaintiffs in the Carter case, which is the assisted suicide case, and it's another case that has just binders and binders of evidence. But in this case, we didn't just sort of shovel all the evidence at the judge. We had all the experts properly qualified, attaching all the research. So they were there, and they were there to be cross-examined, and the evidence was tested, and they were cross-examined. And so I really see Bedford, and I think I hail that decision for doing away with that silly distinction and requiring counsel to re-argue the facts at every level. It's a terrible waste of court time, I think. But when I read Bedford and I see that they say you just have to show an infringement for one person, what I take from that is that they're drawing on a distinction that they've made more clear in Bedford, that Section 1 is still going to have a role to play in Section 7. So I think all that evidence is still going to be required, but the onus, I think the court is sending a signal that the onus is going to be shifted.
Just really quickly, I mean, one of the problems actually is the adversarial system. It's not really well suited for the scientific method, the clash of experts. So, I mean, if you want to improve fact-finding, and it's not just in constitutional adjudication, but in criminal trials too, you might want to go to that, what do they call that thing in Australia? the hot tubbing. It's just a silly name, where it's a more collegial effort where you put a bunch of experts together that report to the court. And I think actually something that would be very valuable, but it's very foreign to us, is allowing a court to nominate experts, not to rely on counsel to select the experts to come forward, but after they've reviewed all the evidence, say, I'd like to hear from an anthropologist on this point. Please find this. Because judges need to make difficult decisions, and we as counsel don't always give them the ammunition they need to make an informed decision. And the thing about being a judge is you can't say, I don't know. You have to make a decision. So we should give them better ammunition. And I kind of like what they do in Europe too, where they take their constitutional issues away from the trial courts and put it into a specialized constitutional court that just deals with constitutional issues. So maybe you have a court that has people that have some knowledge of statistical method and qualitative research and things like that. But it's very transformative of our system. It's not what we do. We rely a lot on counsel.
Yeah, and I would just say, I think this is right. I mean, I think this is definitely a challenge, but I mean, it can't lead to this sort of answer that, well, we shouldn't have this kind of evidence or whatever. I mean, I think judges are going to have to wrestle with it. I think it just means that the nature of judging is different. The nature of actually lawyering in these kinds of cases is different, and it needs different tools and needs different skills. And I think, law schools have a role to play there, judicial education has a role to play there, and then setting some parameters and maybe looking at some of the innovations or alternative ways, I think can play into it. But it's just kind of the new normal, and I think we have to think about how we're going to deal with it.
And if I could just make one final point, is if you think that the Supreme Court of Canada is going to defer to the factual findings of the trial judge, read the Chiuli decision. The Supreme Court will defer to the factual findings of the trial judge to the extent that those factual findings are consistent with the Supreme Court's perspective. One last question.
Okay, changing the topic, although there was a big record in Inglis as well, so maybe not changing it that much. Deb, I wanted to ask, should we think of Inglis as a prisoner rights case? I have some doubts about it because I think it was a case entangled with the rights of innocent children, and there was no real evidence of any security concerns with the program. So is it the kind of case where we don't really see as much deference? And then it also is a case that involved women asking courts for the right to do something society has always been so comfortable having women do, namely take care of children. So I wonder should we be really excited about Inglis, or are these reasons to doubt? So that's one question. And then maybe just to ask Alison about Inglis as well. So there's literature saying that the divide between positive and negative rights is maybe not so helpful or not so revealing. I know as a lawyer you still have to deal with these categories, but in Inglis I'm not sure it really was not a positive rights case, even though there's a paragraph where the judge says that, because there was the positive right to breastfeed on behalf of the child, and there's the positive right that prisoners have to retained rights. Justice Ross cites Solosky and makes a properly big deal out of the idea of retained rights being an active claim that the prisoner could make against the state. So I wonder, does that case maybe show us the distinction between positive and negative rights sheds more darkness than light? And are there reasons to think of Inglis as maybe a positive rights case?
So I guess I'll start because that's the order in which you asked the question. Thank you, Lisa. Really good question. And I should say, one of the things that as someone who goes on and on, as people know about imprisonment and why we should be paying more attention to it and how we don't teach it in law school and all these things, it's actually really great to see some PhD students here who are people doing work in that area and doing really interesting work. So Lisa and Kyle and others who are here. So in terms of Inglis, I agree. So this is the mother-child program case in BC. It doesn't fit some of the characteristics of prisoner litigation where the courts tend to defer. But yes, there was the finding that security considerations had not been really raised or proven by the government in that case. But you got to know that I think government lawyers and correctional officials would say they think there are safety concerns there, and I think you will face that in other cases as well. I don't think we could say, mother-baby programs are never going to be seen as raising any security considerations. I think what the judge did is look at the evidence before her and say, you haven't proven that, and I'm not going to apply some deferential standard in the abstract without good evidence of that. And so I agree. There's lots of ways to read that case. The other thing about it is, again, that it's a case where there was a lot of resources put into it. I mean, like human resources and putting that case together that you often don't see in prisoner litigation because it's simply not funded often, and you rely often on pro bono counsel and that kind of thing. So there's many things about it that are consistent with prisoner litigation and some that are not. So, yeah.
And as to whether it's properly characterized as a positive or negative rights case, I think for myself, I view it as a positive rights case for sure. But what's interesting is that it hasn't been appealed. And so in British Columbia, it's been characterized as a negative rights case, and it does kind of highlight the way in which it can be sometimes challenging to differentiate between those two things, and why in a lot of other countries and in international law, that distinction has been kind of done away with. But I agree also with your comment that as counsel, it is a distinction we have to tend to in court because the courts are very concerned about it still.
So thank you. On behalf of everybody, I'd like to thank the panel for a fabulous presentation. Before you leave, again, Ben and Sonia are going to come up and tell us about next year.
Okay, well, thanks so much, all of you who are left, for coming out this year. We're really looking forward to next year. We're thinking it's going to be mid-April, so watch your inboxes. There are so many people to thank. I'm going to start with thanking all of you for coming. I'm going to thank the panelists, especially for all the work they put into this on just an invitation. And this year, to keep costs down, all we gave them was a thank you card. But I would also, there's one person who we do really need to thank, and we'd like to, Ben and I would like to thank Jamie, because she keeps saying that she's not going to be involved with the conference next year. We're still working on her on that, but just in case she's serious, Jamie, will you come and let us just give you a little bit of thanks for all of the things that you've done for this conference and keeping it alive over the years, just in case, next year you really are taking a break.
I thought you said me, guys. Just to finish off, so papers that you've seen on the website or final versions that are coming, they're always published in the SCLRs. And so keep your eyes open in the SCLRs. They're also available through the York Digital Repository. So they're all freely available online. And one of the things that Jamie's done over the course of the years is to spearhead a project of making sure that they're not just available, searchable on the internet through Hein Online and through other databases, but also freely available in the Supreme Court Law Review archives in the York Digital Repository. You'll receive feedback forms in the next little while by email, and help us make it better, help us help you. Tell us what you enjoyed. In particular, of course, being up here was a great delight for us, and we hope you enjoyed it as well. As Sonia said, next year, correcting for and adjusting for holidays, it'll be as close to this date as we can get it. Please stay in touch, and we look forward to seeing you next year.